What if there's more to the clerk Becky Hill and Alex Murdaugh saga? What if she was simply the person who got caught? By now, most people know the name Becky Hill. The South Carolina Supreme Court overturned Alex Murdaugh's murder convictions after finding what it called shocking jury interference by the former Colleton County Clerk of Court, Becky Hill. Okay? Now, the court concluded that Hill told jurors not to be fooled by the defense. She urged them to watch Alex Murdaugh's language, essentially encouraged them to find him guilty. But let me tell you, after reading James Lasdun's fascinating New Yorker article this weekend, I found myself asking a very different question. Was Becky Hill the only person worried about the possibility of a hung jury here or a not guilty verdict? Or was she simply the one person who crossed the line? So that's the question the article basically asked. I'm Margaret McLean, former prosecutor and law professor, and I'm here to translate all the legal jargon and to take you behind the scenes. If you haven't already, please subscribe to the channel, press the like button, and turn those notifications on. So today, I really want to discuss what may have been happening behind the scenes during one of the most famous trials in American history. Why the New Yorker article raises questions that go far beyond Becky Hill herself. So, as we know, the South Carolina Supreme Court's opinion painted a remarkably troubling picture of Becky Hill. The justices did not describe Becky Hill as a neutral court official who made a few careless comments. They described someone who became invested in the outcome, like, emotionally, professionally, because remember, she wanted to write a book and buy a lake house, and perhaps on a religious level too, which the article talks about. Like, she was behind the scenes doing God's work. The Supreme Court found that Hill told jurors not to be fooled by Murdaugh and his defense, and that she encouraged them to focus on the body language and his movements while he testified. And that's really not good. So the court concluded Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them to render a guilty verdict. Now, think about how extraordinary that language is. I mean, the court concluded she essentially urged jurors toward guilt. And that's what she wanted. She didn't want a hung jury. God forbid that, or God forbid a guilty verdict. The opinion by the court also references Hill's desire for recognition and attention. And the justices pointed to her media activity, her treatment of reporters, and she gave special treatment to reporters, her book ambitions, and what the court called the siren call of celebrity. As a former prosecutor, I'm telling you, that phrase jumped off the page when I read the opinion. Court officials are supposed to, disappear really into the background. They're not supposed to become part of the story, part of the action. Yet, Becky Hill seemed determined to be a part of it from the get-go. And here's where the New Yorker article comes in. So I made a slide presentation for you. I hope you guys will be able to read it. But in the slides here, let's see. So this is I'm going to take myself off and let's see. Stupid technology, right? So I'm going to take myself off for a minute and blow this up. This is the headline of the New Yorker article, and that's what actually caught my attention. So the article basically says up here how a small town clerk's misdeeds upturned the Murdaugh verdict. Becky Hill, a court employee, was trying to maximize the the sales of her book, pressured jurors to consider, oh, here we go, pressured jurors to convict the South Carolina lawyer for the murders of his wife and son. Now, this is the key line. Was she acting alone? And that's the line that really grabbed me. Was she acting alone? So, hopefully you guys can kind of read it. But there's Murdaugh, and of course there's the justices that they all agreed. Those justices right there are the members of the Supreme Court who said all together unanimously that Alex Murdaugh deserved a new trial. There he is. And we're going to see him again. He's still in the orange jumpsuit. And there is Becky Hill. So I'm going to leave us right on Becky Hill. But here's that, I'm going to go back to that New Yorker article because it raises a question that many people find uncomfortable, right? If Becky Hill was worried about a hung jury, was she the only one? Remember what was at stake here. This wasn't just an ordinary murder trial. This was one of the most significant criminal cases South Carolina has ever seen in decades. The trial was covered daily in the national media. There were documentaries, podcasts. The eyes of the world were on Walter Burrow. And one of the most revealing portions of the article, I thought involved closing arguments. So for 6 weeks, prosecutors presented a very specific theory that Alex Murdaugh's financial crimes were collapsing around him. All right, if you watch the trial, there was a lot of evidence about his financial crimes. Exposure was imminent. Lawsuits were mounting, right? And his world was just unraveling. And according to the state, the murders were designed to generate sympathy, create distraction, and buy time. Whether you believe that theory or not, it was a coherent theme that ran throughout. But then came the rebuttal, And suddenly, prosecutor John Meadors suggested something very different. Like maybe he got angry. Maybe Murdaugh got angry. Maybe he got angry at Paul. Maybe he just lost it. And, that caught my attention. Not because prosecutors can't argue, alternative theories. Of course they can. But these were two very different psychological explanations. One portrays a calculating, strategic killer. The other portrays a man who snaps in a moment of rage. So jurors are naturally going to ask, which is it? So the article also contains another fascinating detail. Attorney Mark Tinsley revealed that he discussed the exact point with prosecutor John I can't pronounce his name, Meadors, there we go, shortly before the rebuttal. According to Tinsley, the point that John was making is a point that, he talked to him about lawyer to lawyer in the bathroom. And, lawyers, they talk, they brainstorm with each other, and they test ideas. But what fascinates me is what that may reveal about the case itself. Did prosecutors sense that jurors still weren't fully embracing the financial motive after 6 weeks of testimony? Did they believe jurors needed another explanation? Do they think they had a motive problem? We don't really know, but it's a question worth asking. And I think the whole thing really ties in. Again, not necessarily acting improperly or doing anything unethically. They were prosecutor simply worried after such a long trial, trying to gauge whether 6 weeks of evidence had actually landed with the jurors. And, one thing as a prosecutor that jurors often don't see is really what happens behind the scenes with the lawyers. They're constantly reading the room. Us lawyers, we're looking around, and of course, so are the court observers. They're watching faces and the body language of jurors. They're trying to determine what's really working here and what's not. When do those jurors start yawning, right? So, again, back to the New Yorker article, it leaves open the possibility that multiple people connected to the trial may have been very anxious about what that jury was going to do, where they stood, were they really buying the prosecution's case? So, another big issue that was raised in the article was the Myra Crosby controversy. And that was one of the most controversial episodes, in my opinion, of the entire trial, removal of juror Myra Crosby. And I have a picture of her here in my slide presentation. So I'll take Anita Hill down for a second. And that's part of the article that I will go over. But here is the juror, Myra Crosby. And so I think that, she, by the way, she was called the egg juror. And of course, she was removed towards the end of the trial. Why was she nicknamed the egg juror? Because after she was removed officially by the judge, she wanted to go back into the jury room because she had left some eggs in there. So she was referred to as the egg juror. That's how people remember her. But what many people really don't realize here is that there were quite a number of questions surrounding her removal that have never fully been answered. And according to this New Yorker article, Crosby's tenants, okay, she had tenants, she was a landlord. The article says they were awakened late at night, agents from the South Carolina State Law Enforcement Division. That was SLED. That's basically like the state police of South Carolina. The next day, they were brought to the courthouse, all right? Much of what happened remains under seal, so we really don't know. But according to the juror, Crosby, her tenants, uh, it was all about so the issue was whether she had been talking about the case outside of the court and specifically to her tenants. Now, of course, who's accusing her of all this? It was Becky Hill. But allegedly, according to Crosby, the tenants denied accusing her of discussing the case and claimed they signed these affidavits without carefully reading them because they believed they were simply signing summaries of their interviews. So Crosby, that juror, has consistently maintained that she never discussed the case and that the conversation she had with her tenants involving nothing more than the pizza that was delivered to the courthouse that day. So, I mean, let's be fair here, though, all right? Those documents still remain sealed. There has been no judicial finding that Crosby was improperly removed, but there are competing accounts, and that's what the article talked about. And if you view this whole thing through the lens of the Supreme Court's later findings about Becky Hill, this episode, in my opinion, about removing the juror takes on new significance. So, like before the Supreme Court decision, there were concerns about Crosby's removal. And there's all sorts of speculation going on. But today, that's kind of harder to do because the Supreme Court found Hill engaged in shocking jury interference, right? And because the court found that she inserted herself into the jury process, it also referenced her involvement in events surrounding juror 785's dismissal, and that's Myra Crosby. Now, that doesn't prove Crosby was removed improperly. Again, I'm going to say that, but it does mean people are going to scrutinize every jury-related decision made during that trial. And frankly, that's understandable, okay? Once confidence, though, in neutrality is damaged, every decision becomes suspect, right? So, did Becky Hill act alone? Again, the article goes into detail about, one of the, this has become such an important question because it notes that Murdaugh's lawyers have now filed a civil lawsuit against Becky Hill alleging violations of his Sixth Amendment right to a fair trial. And they have made clear they intend to find out whether Becky Hill acted alone. That means, listen, subpoenas are going to go out. They'll look into phone records, text messages, all sorts of communications. So we may be learning a lot more from that civil trial. And potentially, I would say, a closer examination of conversations that occurred during the trial are going to be looked into. Now, there's currently no evidence that the prosecutors participate in any type of jury tampering, none whatsoever. In fact, the Supreme Court went out of its way to praise the Judge Clifton Newman, and both legal teams. The court specifically stated that Hill's misconduct occurred outside the knowledge of the judge and counsel. All right. However, I'm going to say civil litigation oftentimes uncovers information that wasn't available before. And the defense appears determined to explore every possible avenue. And you know what? Quite frankly, I don't blame them. They're doing their job. So back to the legal part, legal jargon, of course. The Supreme Court ultimately applied the U.S. Supreme Court's Remmer presumption, which means the burden shifted to the state, and the state could not meet that burden. So the court wrote, the state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the juror's verdict was influenced by these highly improper comments. Thus, the justices concluded Murdaugh's Sixth Amendment right to a fair trial by an impartial jury had been violated. So we know that. But despite the strength of the evidence and, the speed of the verdict, the Constitution required a new trial here. All right. So, of course, the article really gets into that. And I'm going to get to the article in a minute, too. So let me go over to my slideshow and put my glasses on and take, again, this is the juror that was dismissed. And she also wrote a book about it, speaking of publicity, saying that she was dismissed unfairly. She felt she was dismissed because Becky Hill felt that she was one of the jurors that was kind of holding out and wasn't quite sure if Murdaugh was guilty, and Becky Hill just didn't like that. But again, did she act alone? So let me go to some of the slide presentation. I'm going to take myself off in a minute. That's the court, Murdaugh's. Okay. Let me read you some of the verbiage from the article. And I am going to take myself off. There we go. All right. So this slide, I don't know if you're really able to read it. I hope you are, but I'll read some of it for you. This part of the article was interesting because it basically talked about, I like some of this verbiage. From the start, the case was marked by stunned hyperbole. I love that, stunned hyperbole. The scope of Murdaugh's depravity is without precedent in Western jurisprudence. One of the many lawsuits against, this is a quote from a lawyer, one of the many lawsuits against him declared, one of the lawyers, an attorney for some of his financial victims told the author, Alex Murdaugh is one of the darkest human beings our state has ever produced. That's pretty crazy. And earlier this month, the South Carolina Supreme Court added a superlative of its own when it overturned the Murdaugh verdict. vacating Murdaugh's 2 life sentences and ordering a new trial. And it basically talked about the breathtaking and disgraceful efforts of Hill. All right, if you can read that. I'm going to go on to another slide that I think is very good. This one is, I think you can read a little bit better. I thought this one was very interesting, this paragraph, because it got into more of Myra Crosby, that juror that was dismissed. Affidavits cited in the state Supreme Court's ruling show that the groundwork for Myra Crosby's removal had already been prepared 2 days before the Mosul visit, and that was the visit out to the house. That morning, Monday, February 27th, Becky Hill informed the judge overseeing the case, Clifton Newman, that she'd seen a Facebook post made by Crosby's ex-husband, Tim Stone, claiming that Crosby had talked about the case while they were out drinking together. That same day, the judge received an email requesting an anonymity, also claiming that Crosby had been discussing the case in the instance with a tenant of Crosby's while Crosby was delivering a fridge. So Judge Newman had a hard time with this, and it turned out, right, that these allegations by Becky Hill were not true. And she couldn't produce any proof of them. So I thought that was an interesting part. If you do read the article, check that out. Here's another area of the article, a little harder to read. Oh, this part is really interesting. This talks about Becky Hill's religion. So I'll read a little bit to you. The religious dynamic may account for an episode that became a key exhibit in the eventual tampering complaint against her. It occurred on the penultimate day of the trial when the jury was taken to visit the crime scene in the Murdaugh's sprawling model estate. Hill described it in her book, which was, of course, as we know, pulled from the shelves because she plagiarized. So she said, God gives us all gifts, and the gift of discernment is shared by many. Some of us, either from the courthouse, law enforcement, or jury at Modal, had an epiphany and share our thoughts with our eyes. At that moment, many of us standing there knew, I knew, and they knew that Alex was guilty. Now, the author of the article goes on to say, that it's very possible that that Hill felt that she was on the side of God here, and she would do what it took to make sure there was no hung jury after 6 weeks. So she was maybe above the law in that way. So I thought that was kind of an interesting insight into Becky Hill's way of thinking. This part of the article, from the author, she said, I've spent, I've spent more than 4 years reporting on the Murdaugh case, and the fact is there were gaps in the prosecution's case. So now he's talking about why one or two jurors may have had some sort of doubt and why there could have been a hung jury, right? So the author is saying there were gaps in the prosecution's case, unexplained tire tracks at the murder scene, evidence deep in the weeds of the phone metadata that arguably tilted more in Murdaugh's favor than against him, the deeply unusual nature of filicide, even among so-called family annihilations. Most kill or attempt to kill themselves directly after killing their families, and almost all target children who are young and defenseless, unlike Paul, who was 22, very tough, and seldom out of reach of a loaded gun. So I thought that was interesting. And the author goes on to say, it seems that Hill wasn't the only one worried. After 6 weeks of laying out the murders as the long gestated plan of a cunning manipulator who'd begun plotting Weeks before the fateful night, the prosecution offered a different scenario in its final rebuttal, which I re-listened to today, right? The prosecutor ended up presenting the murders as a spur of the moment eruption. Quote, maybe he just got angry. Maybe he got angry at Paul. Then maybe he just lost it. Maybe he just lost it. So this month, Tinsley told the author he'd discussed this rebuttal statement with the prosecutor before he gave it, and that, in fact, he'd been instrumental in its conception. So that was the bathroom conversation. Maybe Tinsley was watching and noticing that some of the jurors were just, some of the jurors were just not on his side. And again, Becky Clerk, oh, by the way, I have to say, when I rewatched the rebuttal today, I meant to play it for you, but it got kind of late here. So it was interesting in that the prosecutor in the rebuttal was praising Becky Hill. And of course, this was before all the jury tampering allegations came out. But I was like, oh my God. So those statements make you wonder. So much praise for Becky Hill. She ran the show there. She was very close with the media, as we know. And of course, the Supreme Court said she had the fingers on the scales of justice, right? So I'm getting the picture that this woman was very powerful, and at one point, her son even worked for the courthouse. So I think it was very, very tight knit, small community in that courthouse, and she really, really wanted him. She believed he was guilty, and she hated to see one or two holdouts take the trial down. Okay, very interesting. So I'll take this off because now it is hard to read. Oh, you know what? I will read this slide for you, and I'm gonna do this because this is the end of. Yeah, this is the end of the article that I thought was well written, okay? It says, last week Murdaugh's defense team announced they were suing Hill for violating Murdaugh's Sixth Amendment right to a fair trial, which we talked about. They vowed to find out whether Hill had acted alone, and if given the power, they will likely subpoena phone and other records from many other people involved in the case. It's a little sickening to think their client could benefit from a civil rights suit. Alex Murdaugh, according to the author, is a detestable human being by any measure. He stole mercilessly from vulnerable people who trusted him. He almost certainly murdered his wife and son. But of course, a great deal hangs on the word almost, and no one is served by a trial in which the uncertainty is disposed of by cheating. I thought that was very well written, and it was an interesting, a very good ending to the article. So if you have a chance, if you have Apple News, definitely read it if you're interested in the Murdaugh case. So, what's my train of thought here? One second. It is getting late. So I think that honestly, the author, I think the word almost, that single word to me may explain why the Supreme Court ruled the way it did. And again, not because the evidence was weak or the justices believed that Murdaugh was innocent, but this is important because our system is built on the idea that almost is not enough. All right. The fundamental fairness of the process is key. I mean, I'm sure all of you have served at some point as a juror, and I think the court overturned the verdicts because it doubted that very process. And that is the deeper theme running through both the Supreme Court's decision, in my opinion, and this New Yorker article. Um, it really is. It's all about the fairness of the process. So ultimately, this article really asks us to think beyond Becky Hill and whether she acted alone. Was she the only person worried about how the case might end? We really don't know, okay? Was she the only person discussing the jury? We don't know. Did she act entirely alone? And you know what? That remains to be seen. What we do know is this. The South Carolina Supreme Court concluded that one court official crossed a constitutional line. And now, as civil litigation begins, all right, and a retrial approaches, we may learn much more about what was really happening behind the scenes during one of the most consequential criminal trials in modern American history. And that story may prove every bit as fascinating as the murder trial itself. Well, thank you for listening and watching the Margaret McLean Show. That's all for now, but I will, again, make sure you subscribe, press the like button, because I will be following this and many other cases as well.